Shall we start? Good afternoon, students, teachers, law practitioners, ladies and gentlemen. I'm James Chiu. I'm a graduate of Hong Kong University, but from medical school, not from law school. And it is my pleasure to introduce my co-author, Professor Robyn Carroll, who will be the speaker of this seminar. Now, Professor Carroll is a professor at the University of Western Australia Law School, and where he teaches and researches contract law, remedies, dispute resolution, family law, and elder law. In 2014, Professor Carroll was invited by the Hong Kong Department of Justice to write a research report on the enactment of apology legislation, which assisted in the preparation of the consultation paper on the enactment of apology legislation in Hong Kong in 2015. She's a co-author of the recently published Carroll, Chiu and Vines Apology Ordinance, Chapter 631, Commentary and Annotations by Chiu and Maxwell, Hong Kong, in March this year. So just over a month ago. There's some copies are over there. So, without further ado, ladies and gentlemen, shall we welcome Professor Carroll.
Thank you, James, and thank you to the organisers of today's seminar, the invitation to attend here at Hong Kong University, and to speak about this new ordinance came into operation in Hong Kong in December of last year. It may seem a little strange to have an academic from Western Australia talking in Hong Kong about a new piece of Hong Kong legislation. But that arises because I have been writing about apology legislation in other parts of the world for some time, and I was invited up here to speak in 2014 when the Department of Justice was looking at introducing apology legislation, and then was involved in the report that was mentioned by James, and then eventually writing this commentary, which draws largely on the experience in other jurisdictions. So that explains why I'm here today. The enactment of the ordinance has its beginnings in the recommendation in 2010 of the working group mediation to consider whether there should be legislation dealing with apologies for the purposes of enhancing settlement of legal disputes in Hong Kong. So we see the apology ordinance being birthed from the mediation ordinance process, which I think speaks a lot to what its objects are, which I'll explain further as we proceed. So it was passed in July last year by the Legislative Council. The ordinance then commenced, the commencement date was the 1st of December. It's very short, 13 sections and a schedule. And this is an outline of what I'm going to speak to in this presentation, which I'm hoping to time for approximately 30 minutes, and that will leave another 30 minutes or so for discussion. I'm very interested to hear what people have to say and to answer any questions. So I will give you an introduction to apology protecting legislation, an overview of the ordinance, how it relates to mediation ordinance and mediation here in Hong Kong and elsewhere, very briefly, and then some concluding remarks. Before I move into to that in any great detail, I think it's very useful to think first about what we mean when we talk about apologies, because then when we put apology legislation into effect, the question might be, well, what does it have? Well, how does it really work? What is its relevance to apologies? So I'd like to just sort of step back a little and begin by thinking about the realities of life and the fact that accidents happen. This is not a Hong Kong school bus, I suspect, but it's to represent the fact that when accidents happen, people get hurt. People are very hurt. Now, being a school bus, it's quite possible that there were children seriously injured on board the bus. So not only would the child perhaps have suffered serious physical injury, They may also suffer psychological injury, and their parents and family no doubt would suffer considerable distress as well. When accidents happen, then of course, once the immediate physical needs are dealt with, we start thinking about, well, how can that be repaired in some way? And we know our legal system focuses very much on financial compensation to put people in the position they'd be as if the accident never happened. There's also other things that can happen. People can realise that they might want to make good in a social way and in a psychological way. So I'm going to go through with you some examples of what might be said and how that might be relevant to the legislation. A person might say, "I'm sorry." I'm sorry. That wasn't a cue for you to say. People do say sorry all the time. I'm so sorry. A person might go further. They might say, "I'm so sorry, it's my fault that you were injured." The bus driver might have to say that. The bus driver might go further. For example, "I'm so sorry, it's my fault that you were injured. I was distracted by one of the other passengers on the bus. I looked away from the road for an instant and I drove into the barrier." They might also say, "I will pay you compensation and be more careful in the future." Using this as an example, let me mention what the psychological research and literature, as well as other sociological and philosophical literature and research will tell us. And that is that we can think of apologies as having components. There's no one fixed definition of what is an apology for all occasions. I'm sorry because you walk in front of someone or because you come a little bit after the starting time is a very polite social way of saying excuse me or forgive me for intruding. We also know apologies that can be very meaningful after there's been very serious harm. But the components that can be easily identified from an apology are these. Firstly, there's an emotional component where a person expresses the emotions that they want to convey to the other person. It may be regret, it may be remorse, it may be sorrow and sympathy. We often associate that with an apology of these expressions of emotion. The second of the three components I'm going to refer to is what's a more cognitive feature of an apology. That is when a person thinks about what's happened and they share with the other person their thoughts of responsibility, their thoughts of acknowledging that there's been something wrong happen, acknowledging their role in that they may be at fault. It may be an admission and an affirmation for the other person, that the victim, that they're not the wrongdoer, but that the person who's making the apology is the person who's in the wrong. And then there's another aspect, the behavioural aspect. It may be the eye contact, it may be the facial expressions, it may be the way that a person, the way they present their apology to a person, that these are all behavioural aspects, but also it may be an indication that a person will change their behaviour. I will be more careful next time. I will pay you compensation and I'm sorry. So this behavioural aspect usually relates to what someone's going to do in the future to help with the repair.
Thank you, Professor, for allowing me to ask. My name is Gary Meggitt, that's just so people know. I've actually written a CPD course for registered solicitors upon the legislation, which obviously is useful to them because legislation has only just come in force. My background is I'm a litigator, a past insurance litigator. I'm not going to ask you lots of questions about how it works with insurance because that would probably be boring for people who don't know about insurance. But there's also a cultural aspect, isn't it, to apologies. I'm English. We say sorry almost all the time. We're accused of saying sorry almost all the time when we don't actually mean it. And there's also the fact that, as you will well know, because it's in the papers that I've read that you've contributed to, that there's a question of sincerity, which comes back to the English point, but also insincere apologies. I'm reminded, and it shows that I'm not only an insurance lawyer, I'm a geek. There was a TV programme, a science fiction TV programme, which one of the main characters was told he had to apologise for something he'd done by his superiors. And his apologies, he rehearsed it in front of his shaving mirror. He's about to give it. I'm sorry that you idiots opened fire on my spaceship and that I had to blow you to bits. And he said, but it's the thought that counts. And I wanted to ask you about that because clearly there are cultural aspects in Hong Kong. You have a mixture of Asian culture and the Western culture and the commercial aspect of it as well. Without bogging you down, how do you deal with that aspect?
Well, what I'd like to do is, I'd certainly like to discuss that. What I'd like to do is do the overview of the legislation and then come back to those questions.
Yeah.
I could give another talk on the meaning and functions of apology, but that's not my aim today because it's mostly to focus on the legislation. But you've made a very good point because in talking about what are the components of apology, of course, there is much more to it than that, including the fact that what is appropriate expression of emotion, what is the appropriate admissions to be made, and what is the appropriate behaviour is all very deeply cultural, and that has to be taken into account. And that the need for sincerity is one of the key things that people were looking for when an apology is made. So,
Thank you very much for your question. But Professor Carroll has kindly allowed some time for Q&A afterwards, so maybe 20 to 30 minutes afterwards.
Yes, I had that.
okay. Now, one of the reasons for giving you this example is just so that I can use the examples from the accidents happened, the bus accident, which is only one of the million different ways that things can happen that inflict harm on people for which an apology may be appropriate or needed. One of the reasons for doing this is to use this as illustration as we work through the sections of the ordinance, because on its own it may not have as much meaning. So what I'm going to suggest to you here is if you looked at this, I'm so sorry, that would clearly be some form of an expression of emotion, not a great deal I would suggest, but then it's my fault. That's the admission component of the apology, the cognitive aspect I mentioned. And then we have a lot of factual information. This is why it happened, this is what happened, and this is what I'm going to do in the future, the more of the behavioural future focus. So I'll refer back to this. The common features of the purpose of apology legislation and what the Hong Kong Apology Ordinance does is it seeks to take away some of the legal consequences if a person were to make an apology of this nature. All of you, I imagine, could see that if a person who has caused an accident says these sorts of things, that it's possible that what is being said could be admitted in a trial if ever the plaintiff in the case was to sue for damages. So they sue for damages and they say, and you admitted that you were at fault and I'm going to tender as evidence your apology. And with it, I'm going to tender evidence of all the things you said because that will show how the accident happened and it was your fault, and therefore it'll be a slam dunk for me. I will be receive an award and then damages will follow. So the apology protecting legislation is designed to remove some of the fear that a person may have of making an apology, that what they say will be used against them in litigation. That's the key feature. So the key feature of apology legislation is to amend the rule of evidence that says that an admission is admissible in a civil trial. So in theory, a person will say, well, I can apologise because I don't have to worry about it being used as evidence against me if the matter goes to court. There's about 56 jurisdictions around the world that have apology legislation. And I might mention at this point that this is the first one in any Asian jurisdictions that have been introduced. But of those 56, the majority, it's fair to say, only protect what's known as, only protect an apology that isn't an admission of fault. So it's often said it's a protects the partial apology. So in many jurisdictions in the US and in some Australian states, for example, where I'm from, an apology would be inadmissible only to the extent that it said, "I'm so sorry." That would be inadmissible. The rest of what is said here would be admissible. So the admission of fault would still be admissible as evidence. So the apology legislation in those contexts really just says to people, go ahead, say sorry, there won't be any consequences of doing that. But it doesn't protect the next step, all the rest of what's here. All right, so it's often said that protecting partial apologies doesn't really achieve a great deal. Other jurisdictions, New South Wales and Australia, for example, and Canadian provinces, there's some seats in here if you like, Canadian provinces and territories went further when they enacted apology legislation, and they protect a full apology. In other words, they protect an admission of fault within an apology. So in Canada, for example, "I'm so sorry, it was my fault that you were injured," all of that would be protected. The rest of it, though, all the facts would not be formed part of the apology, and they would be admissible in evidence in Canadian case, for example. So that gives you an idea of what the common features are. It's a change to the law of evidence to reduce what it is that can be, the amount that can be admitted in evidence of an apology. It's generally, as well, the common features, they only ever apply in civil proceedings, so don't apply to criminal proceedings. So if a person apologises, it can be used in criminal proceedings. And another feature that Hong Kong has in common with some other countries, but it's not common to all other countries, is development in the British Columbia legislation in Canada, which was then followed in other jurisdictions in Canada, was to introduce a provision that said that any term of an insurance contract that said that if you apologise or admit fault, you can't rely on your insurance policy, will be void. So it changes the ability of an insurance company to include as a term in a contract a no admission clause, or a clause that will mean that a person can't claim on their insurance. So that was one of the features that is in all the Canadian jurisdictions, and was picked up, as you'll see shortly, in Hong Kong. The distinctive features that I would suggest to you about the Hong Kong legislation is that it has the broadest meaning, broadest statutory definition of apology, to include essentially everything that I put on that previous example. It applies to the broadest range of non-criminal proceedings. It in fact applies to all civil and all non-criminal proceedings, except a very few named ones which are set out in the schedule. And it applies retrospectively to insurance contracts. So I'll come back to these distinctive features shortly. So you can see then, since 1986 in the US, in Massachusetts, where the first legislation of this kind was introduced, that there has been various waves, this is a term that James has used in what he's written about apologies, the waves of apology legislation and arising differently, but looking to previous examples and enactments in each case. So we go from the US with, I think 36 of the states have some form of apology legislation, to Australia, where all the states and territories have some form of legislation that will protect an apology, but it varies what they will protect. To Canada, where most of the provinces and territories have the legislation, Quebec doesn't. Then Scotland, who introduced an Apology Act in 2016, and now finally Hong Kong. So the next bit of my talk will focus on the provisions, the legal provisions of the ordinance, so that we can then have a discussion about how that might work. So the object is set out in section 2. It is to promote and encourage the making of apologies with a view to preventing the escalation of disputes and facilitating their amicable resolution. So hold these in your mind. Once we've looked at all the provisions, you'll be able to see more clearly how the ordinance aims to achieve these. But it's clear that it's trying to effect a change in apologising culture, perhaps not change Hong Kong culture as such, but to try and change the culture of offering apologies when things have happened that have caused another person injury or harm in some way. And whereas the Mediation Ordinance has an object, one of the objects of the Mediation Ordinance in Hong Kong is to facilitate the amicable resolution of disputes. This ordinance has that, as well as preventing the escalation of disputes. And that's because this ordinance is designed to protect a person who makes an apology right on, early on. So the bus accident happens, the apology is offered, you don't wait until the lawyers are involved or until a mediation might be held and so on. So the meaning of apology in the ordinance. If you think back, I talked about what apology, what might be found in an, understood to be in an apology in terms of from a psychological, social point of view. This is what the legal meaning of apology is, and it's drawn on that psychological research and the research about the effectiveness of apologies in settling disputes, essentially, and reconciling parties and providing some kind of repair and restoration. In this ordinance, an apology made by a person in connection with a matter means an expression of sympathy, regret, and benevolence. Now, I've highlighted some parts in red, and I'll just speak to each of those briefly. So, in connection with a matter. So it means that we're talking here about an apology that's been made in connection with, let's call an adverse incident, an accident, or some kind of tortious conduct. It may be false imprisonment. It may even be battery and other economic torts. So virtually any tort you can think of, whether it's a common law or in statute, is a matter to which this apology might relate, as well as contractual and commercial disputes, as well as any non-criminal matter that might arise under legislation. So a matter is very broad. It's not just accidents, even though I used that as an example, because I think that's the one that most quickly comes to mind. Then you see that it means an expression of regret, sympathy or benevolence, an expression that the person is sorry about the matter. That, I suggest to you, is picking up the emotional component. However it's expressed in whatever culture, it's still focusing on this emotional component. So then the section goes on. The expression may be oral, it may be written, or it may be by conduct. So it doesn't have to be spoken words. This is the best example of this, I think, is that expressions of sympathy or benevolence can often be made and communicated without being spoken. Offering to pay someone's medical bills, for example, after an accident, offering to have someone's car repaired after an accident, they may be seen as acts of benevolence. They're not necessarily admission that you did anything wrong, but you may feel responsible for what's happened. And so this protection of acts of benevolence is actually what the very first legislation in Massachusetts in 1986 was aimed at. It was aimed at encouraging people to be sympathetic and benevolent, even if it wasn't protecting them from making an admission of fault, which is what the law is in Massachusetts. Okay, so it's a very broad definition of what an apology. It doesn't have to be the words "I am sorry" or "I apologise." Then we move on to part 3, and this is where we really see some development in the law from Canada and now further in Hong Kong. The apology also includes any part of the expression that is an express or implied admission of the person's fault or liability. So I was at fault, I was negligent, or I breached the contract. Those sorts of things would establish liability. And so if we went back to this example, you can see that it would include the express words, "It was my fault." That's this part of section 4.3a is in common with other jurisdictions that also protect what's called the full apology. So the Canadian jurisdictions, some of the Australian jurisdictions, the Scottish legislation, and now Hong Kong. And then there is the additional provision in Hong Kong that says that part of an apology can include the statement of fact in connection with the matter. And that's why I use the example of the explanation given by the bus driver as to how the accident happened, what the facts are. So I'm so sorry that this happened, and explaining what happened. The research shows that people, where there's been accidents, people like to know what's happened. They primarily want to know that the person is sorry that they've done it, they want to know what happened, and they want to know it won't be done again. And this has come out particularly in incidents involving personal injuries and in the healthcare sector, that people are very concerned to know that accidents won't be repeated, they can be avoided. And to know what needs to be changed in the future, we have to know what's happened, and therefore for many people, knowledge about what's happened, the statement of fact, is an integral and important part of an apology. So the fact that Hong Kong has then included a statement of fact in the definition of apology means that the protection that is given to a person making an apology is much broader than it is in other jurisdictions. So whereas in the Canadian cases, which have the equivalent of A, but don't have the equivalent of B, a court may be asked to decide whether, when a person said the things that our bus driver has said, which part's the apology, which is inadmissible, and which part is a statement of fact that is admissible. And the courts had occasions to go through and separate them out. The decision of the Hong Kong government in passing it in this form was to say, as long as the statement of fact is in connection with the matter and it is included in the expression of the apology, then the whole statement is protected. And the reasoning is that then people making a spontaneous apology will simply say what they want to say without going, can I say this, can I say that, which bits will get me into trouble. They can simply tell things as they are and express an apology and be protected by the legislation. Paragraph 4, which I haven't included here, but I think is important, is that an apology includes an apology made on behalf of a person. So if a hospital was to offer an apology on behalf of, let's say, the doctor who was negligent, it's still an apology that's covered by the ordinance. And paragraph 5 says that the ordinance only applies to an apology as set out in section 5. So, in terms of the scope of the ordinance, what sorts of circumstances, the circumstance which will apply, section 5 tells us that it only applies to an apology made on or after the commencement date. So it only applies to an apology made on or after the 1st of December of 2017. And there are some circumstances set out in section 5, subsection 2, where the ordinance doesn't apply. I won't go into that in detail. You could look at it, it's fairly self-explanatory, but essentially it's if by consent the parties agree to the admission of an apology in legal proceedings, then the ordinance doesn't have any reason to apply. And also apologies made in the course of court proceedings. So if a person is a witness and during their examination or cross-examination they make an apology, then it's already in evidence, it's admissible. Because it's seen that people have the opportunity outside of the litigation process to make an apology and be protected. But if you choose to litigate, then apologies made in the course of litigation is not offered the same protection. Which proceedings? I've already explained that Hong Kong has a very wide range of proceedings to which it applies. They are set out in section 6. The proceedings to which it applies are judicial, any court proceedings, arbitral, administrative, disciplinary and regulatory proceedings. So, as I said, very broad. Any proceedings in which a person, a decision maker, might receive and hear evidence and make findings that will affect another person's rights and liabilities and for which there will be civil consequences, damages or any other remedies, any of those proceedings are proceedings to which this legislation applies. And we'll see in a moment, Hong Kong is the only legislation that has extended this to regulatory proceedings. So that's a bit of a new frontier that we'll yet to see what that will mean when regulators are conducting proceedings in relation to non-criminal matters. So in that sense, it is much broader. In many places elsewhere, it only talks about civil proceedings, and sometimes certain proceedings are excluded expressly. In Scotland, for example, defamation proceedings aren't covered, but that's because they're regulated by UK law, not Scottish law. And it's also fair to say that many of the jurisdictions that do provide for apology legislation confine it only to certain areas in which disputes might arise. So many of the jurisdictions confine it to either the healthcare setting, so it's designed particularly around medical negligence cases, or it might be confined to personal injuries or damage to property cases. So very much around the tort of negligence. But whereas Hong Kong says any wrong or any tort action and in any proceedings, so much broader coverage. There are a few sections which it expressly says that other laws aren't affected. So the rules of discovery still apply. So in the litigation process, it matters if parties are in the litigation process, then they still have to make discovery, and that mean that they have to discover a document in which an apology and a statement of fact is made. Once it's discovered, of course, then the admissibility rules will come into play, and it will be inadmissible unless there is, as you'll see, a very small exception that might apply. But it's in mediation under the Mediation Ordinance, even though mediation communications are confidential and inadmissible, the rules of discovery still apply to those if there are litigation on foot as well. The Defamation Ordinance, if you're familiar with defamation law, you'll know that there are defences available to a defendant. So if a defendant publishes a defamatory statement, but then publishes a correction or an apology, or offers to make an apology or correction, and that is not taken up by the plaintiff, then it might be, under the terms of these sections, the circumstance in which the defendant will actually have a defence, and they can say, I'm not liable because the plaintiff didn't take up the opportunity when they could have. And if the matter does proceed to a trial, then it will be relevant to mitigation of damages that there was an apology or a correction published. And so the third example is the third area in which the law is not affected is the Mediation Ordinance. So Mediation Ordinance, you may be aware, says that anything that's said in mediation is confidential and it's inadmissible in court proceedings. So it already creates a protection for things that people say to each other when they're trying to resolve a dispute. And so it already protects an apology, in fact. And so the Mediation Ordinance is doing the same thing, but for a broader purpose of encouraging parties to resolve their disputes privately, in confidence, and outside of court. One of the things that could be said in mediation is an apology. So all three of these rules, these areas of law, not affected by the ordinance, according to section 11, can be seen as laws that are designed to encourage parties to resolve a dispute, to settle their disputes through what they say to each other. Probably only the Defamation Ordinance is specifically about apologies. And the ordinance applies to the government. So when it talks about a person making an apology in connection with a matter, the person can be the government of Hong Kong. All right, so that's how it can operate. Then we'll say, well, what does it actually change? What does it do to the law? Some of this I've already touched on, so I'll go through it fairly quickly because I explained what the common features of apology protecting legislation is. But in terms of this particular ordinance, Section 7 says that an apology made by a person in connection with a matter does not constitute an admission of fault or liability. Right? So it can't be an admission. And it must not be taken into account in determining fault, liability, or any other issue in connection with a matter to the prejudice of the person. Those words, or any other issue to the prejudice of the person, are unique to the Hong Kong legislation. The other jurisdictions don't couch it in such broad terms, so that's an area where it'll be very interesting to see how the law develops. Having stated in subsection, in section 7, what an apology cannot be used for, section 8 then goes on to say an apology is not admissible evidence in applicable proceedings, right? And that is unless section 8.2 applies, which we'll come to in a moment. These are the main changes to the evidentiary status of an apology. So an apology loses any of its legal effect that it might have had in court proceedings as evidence of fault or liability. So not just court proceedings, disciplinary proceedings, regulatory proceedings. An unlikely to arise scenario, but is covered by the ordinance because they want it to be comprehensive in the cover, is that an apology is not an acknowledgement for the purpose of section 23 of the Limitation Ordinance. So essentially if a person was to say, oh, I know I owe you that money and I'm terribly sorry, that wouldn't be an acknowledgement. That would then be used to extend a limitation period. Those of you who know limitations law are nodding, and so it's a very small point. I can't imagine a person often doing that, but it's just to make sure the field is covered. Importantly, another key feature of the legislation is that it says an apology does not void a contract of insurance or indemnity. So that is a very important provision, and that applies retrospectively. So although the apology, it only applies to an apology made from December 2017 onwards, it can apply to a contract of insurance that was entered into at any time before that. So these are the operative provisions. Perhaps the most, the section that caused the most debate as it was proceeding through Legislative Council was whether or not this protection should be extended to the statement of fact. Not just the I'm sorry, it was my fault, but the what goes beyond what we normally think is apology, but the explanation component of an apology. All those statements of fact that might be used by a plaintiff to build their case and now would be excluded under the ordinance. Of course, if you go back to our bus driver example, and the bus drivers explain what happened and why it happened, the plaintiff will have heard those things. If it's in writing, they'll read it. If it's been said to them, they'll know what the explanation for the accident was. And in most situations, you'd expect to be quite able to prove independently exactly what happened in order to establish liability. So it's not as if the apology means that you can never prove someone's liable. It just means you cannot use that piece of evidence. But the facts will be provable. You say to the bus driver, so what happened and what happened then and what did you do? And unless they're going to perjure themselves, they'll say, I looked the other way when I was distracted by a passenger and I ran into the barrier. So all of those sorts of, all of that evidence can be admitted in another way, just not in the form of the apology. I make that point because I think it shouldn't be overstated what the effect of the ordinance is in terms of the ability for a plaintiff to prove their case. So given that Section 4 says that an apology includes a statement of fact and that Section 8 says that an apology is inadmissible, there was the concern that perhaps it does create a situation where a plaintiff might be in a very difficult position if they can't prove what happened in any other way than through admission of the apology. And so, in a sense, to ameliorate that possibility, Section 8, subsection 2, creates an exception to the inadmissibility provision, only in relation to statements of fact, not in relation to the expression of sorrow or the fault implied or expressed admission of fault, only in relation to the statement of fact. So evidence of a statement of fact in an apology, I was distracted, I ran into the barrier, may be admissible if in particular proceedings there is an exceptional case. Now, exceptional case is not defined, but in the legislation it does expressly say in the section that an example would be where there is no other evidence available for determining an issue. That's one example of what is an exceptional case, and I must say it's hard to think of what other examples of an exceptional case would be, but we might recognise it when it arises. Where there is an exceptional case, the decision maker, the judge, the arbitrator, or whoever's conducting proceedings, has a discretion. They can admit the statement of fact, but only if they're satisfied that it's just and equitable to do so, having regard to the public interest or the interests of the administration of justice. And these terms of what is the public interest and administration of justice, there's Hong Kong law around what that would mean. It's been an issue that the courts have looked at in various contexts. I would suggest that it's going to be very contextual. It's going to be very much on what sort of claim is brought, in what sort of proceedings are brought, what is the public interest in the litigation, and why a decision maker may believe that it's necessary to admit the statement of fact. So it would be highly speculative for me to say exactly what this would mean. I think it would be much easier to do that as cases arise, if they do. So that's probably one of the most remarkable features of this legislation, although I think others will in time show themselves to be as well. Just by way of finishing, because from a dispute resolution focus, I think it is interesting to look at the interaction between these two pieces of legislation that arose from the same process, and have, as I said to you, an overlap in their objects. Both ordinances provide legal protection of an apology by making it generally inadmissible. I say generally inadmissible because even mediation communications can be made admissible by court order under Section 10 of the Mediation Ordinance, just as I've explained to you under Section 8.2, a component of an apology can be admissible under the Apology Ordinance. So this is the main difference. The Mediation Ordinance provides protection to an apology made in mediation. And as you know, mediations don't happen on the roadside after there's been a bus accident. Mediation will usually happen sometime down the track, and it may well be after the parties have become relatively positional about their circumstances and what they're looking for. Whereas the Apology Ordinance provides protection to an apology from the time the apology is made. So there's a window of time where it may be possible to either prevent the dispute escalating, or for some resolution, it gives a possibility of the spontaneous apology or the apology made in response to a request earlier on. Now, so it extends protection, in other words, from what is available under the Mediation Ordinance. Of course, it is very important to bear in mind that the Apology Ordinance doesn't mean that you must apologise. A person does not have to apologise. It doesn't mean that a plaintiff has to accept an apology. It doesn't prevent a plaintiff saying, well, I'm going to sue you anyway. They may have reasons why they want to proceed with the suit. And it doesn't affect any of the entitlements that a plaintiff has to be compensated or to receive any other form of remedy. It's simply trying to free people up to express an apology earlier on if that's what they want to do. So in conclusion, in terms of the legislative design, the objects of both of these ordinances are complementary, aiming at promoting amicable resolution of disputes, and apologies are just one component of that. I certainly recognise that an apology may not be culturally appropriate, or may not be appropriate at all, or that it may be insincere and people have to deal with that. All of the issues that surround what is an apology, what's a good apology, what is an appropriate apology, remains untouched by the law, essentially. It's something that needs to be considered. What it does is it creates opportunity for dialogue in this particular form of dialogue earlier on, and who knows, perhaps if people are more willing to be free in what they say to each other early on, it may narrow the issues between the parties. You might, for example, have the parties agree on something such as they may agree on what happened and a whole lot of things even though they may still contest whether there's legal liability, and that may need ultimately to proceed to the litigation process. So that concludes my summary of the legislation. Very happy to take questions and for any discussion or any comments. I'm happy. Sorry, let me just. I'm just going to go back to. Or I won't. We'll just leave that blank. Won't let that distract. Now, I'm happy to go back to it if there's a particular question, but I think actually, I think your comment was well made in that when we talk about apologies, they're not, they're not one creature. It's like it's a whole menagerie, really, isn't it? I am aware of the fact that when the legislation was being debated or submissions were being made in Hong Kong, that there were concerns expressed about the transportability of research in Western jurisdictions into the Hong Kong scenario, and whether or not you could say that the effectiveness or the little bit of empirical research that points to apologies as being effective and apology legislation as being effective to reduce litigation and improve the rates of settlement and the speed of settlements, whether that was really transportable into Hong Kong society. And I think there were differing views on that. The Ministry of Justice's view, as expressed in their reports, was that largely in terms of the litigation culture in Hong Kong, it's very similar to common law, other common law jurisdictions. So looking more at legal culture being similar to other jurisdictions as distinct from social culture, perhaps. And maybe that's a distinction that you would...
Well, yeah, I mean, there's that. I mean, in terms of culture, it bears upon what you were saying about mediation as well. As Dr. Chiu will be aware, Hong Kong Mediation Handbook, the Asian Museum chapters on culture about mediation, also chapters in other texts about culture. One thing that's said is, what do you mean when you say yes? According to writers, and I if they're correct, they're correct. If they're not, they're not. In local culture, by saying yes, maybe in the context of negotiations, you're actually saying, let's talk. Whereas in the West, saying yes is, I agree.
I accept.
So something as fundamental as the definition of yes, which reminds me of Bill Clinton's testimony 20 years ago when he argued what the definition of is was. These things are essential, especially when you are talking about apologies. And again, coming into the context of mediation, you spoke about mediation there, and what you say, mediation communication, is it admissible, is it confidential? I mean, essentially the rule on mediation is it's non-disclosable. It's not privileged, it's not confidential as such. Legislation, specific, as you're well aware, specifically says these are things you can think about. But of course there are also exceptions. I personally think the Mediation Ordinance is quite porous. Section 8.2.
There is a lot of exceptions.
Section 8.2 basically says you don't need permission from the participants and you don't need the court's leave for a variety of circumstances. Some of them quite justifiable, where, for example, a child's welfare is at risk. But even though I'm an academic, I don't think that Section 2E is justifiable by saying we can anonymise the information and release it for academic research purposes.
Yes, there are.
That's a matter of debate.
Yes, yeah. Okay, well, thanks for those comments.
Yes, I may supplement that in Hong Kong we are bilingual, so we have the Chinese version of the Apology Ordinance, and this was debated quite a bit in the Legislative Council because I attended the sessions every time they have it, and a few councillors did ask this type of questions. So I purposely write something on the book we have. I have written down the meaning of apology in English and Chinese versions of the ordinance, and also in the appendix there's a history of the development of the Apology Ordinance. So it gives the background of this.
I mean, your consultation paper also discusses the various court cases as well, overseas and here. You had the former Chief Justice give a very pithy definition of apology. In other cases, defamation there was quite lengthy. Lots of lovely time for lawyers to spend backing up fees potentially?
Well, I think that, one of the ironies is that this legislation is designed to reduce litigation. That's part of the agenda. And so in crafting the legislation, the aim was to avoid satellite litigation arising around legislation designed to prevent litigation. It's inevitable that there will be satellite litigation. If there isn't, that'd be a good thing, but it might suggest that no one's actually applying the law, legislation at all, because we would expect people to be coming before the court saying, well, what do the words actually mean? What has the Legislative Council intended in these visions? And of course, that's what made it very interesting to write a commentary on an ordinance on which there is no court commentary yet. So we have used examples from other jurisdictions around the world to try and say, well, suggest these words would seem to mean this using the standard methods of statutory construction. They'd seem to mean this based on what's been decided in other jurisdictions. But until the court in Hong Kong decides a matter, then it's not a matter of law. And so there's a few key obvious points where the courts may be asked to say what it means or and apply the legislation. I've pointed in particular to the statement of fact and exactly where does an apology end as defined to include statement of fact, and where does it go beyond that, because we would want to ensure that a defendant doesn't package every single thing they want to say that could be prejudicial to them into an apology so that it sterilises that for a plaintiff. My suspicion is, my thought would be that courts will see right through that, and they will not allow the legislation to be used essentially as an instrument of the defendant to avoid any liability. So there's a number of interesting points which I think we have to hope there will be some litigation. But for the purposes of the public interest, to know what the legislation means, rather than to in any way bar a plaintiff from bringing a claim that they should otherwise be able to.
The question of satellite litigation has been raised during the consultation period, and it's been discussed in the consultation papers. Right? But the Department of Justice says that actually there's been no evidence that there's been increased in satellite litigation in overseas jurisdictions. And in Hong Kong, because the Apology Ordinance is so comprehensive, and I think the chance of satellite litigation will be much, much less than in other jurisdictions which protects partial apology and also does not protect the statement of fact. So I think probably not many cases in Hong Kong will be generated because of this.
If the defendant says something that's inconsistent during trial, and you were trying to rely on the previous statement, apology, would you be relying on Section A2 as an exceptional case?
No, I don't think, in those circumstances, if I understand your question, so if a plaintiff knows that a defendant has, let's say you have a written apology, they've said it out in the letter, they've said they're sorry and what happened and why they're sorry, and then when they're giving, if the matter proceeds to trial and that's inadmissible under Section 8.1, if the defendant then takes a different stance and is saying facts other than they've said previously, or is not admitting facts like the cross-examination that they've already said in letter, how could it be admissible? I guess it could build a case that there is an exceptional case as to why it should be admissible under Section 8.2, but I don't think that's what it's designed for at all. It's not intended as a backway door to put evidence in statements of fact in evidence. I think that where that becomes is that if a defendant is saying something inconsistent with what they've said before, it raises the question of whether they are telling the truth or not.
Yes.
And therefore you use submissions or arguments relating to reasons to believe that the defendant is perjuring themselves, that they're saying inconsistent facts. Now, how that is, I guess, the matter that is going to have to be brought to the court's attention in some way. Certainly it's not an issue addressed in the book. I'd be interested to see what are the ways in which that can be addressed. But I think it might relate more to submissions that there is an offence being committed through perjury, and in which case the apology is not inadmissible if it relates to a criminal offence. So that's my answer to you. But I think in terms of the statement of fact, it has to be exceptional case, whereas you might say that people saying one thing on the stand, which is different from what they've said previously, is not an exceptional case at all. Maybe happens quite frequently.
Do you think lawyers might also try to test whether certain apologies are admissible, even if they know the judge won't let it in, just so that the judge knows
that there is
the true circumstances?
Well, I guess that happens a lot already anyway. Judges are always being asked, always having things put before them. For example, in contractual disputes, people put evidence as what their subjective intention was, even though they know that the law is going to say that's inadmissible under the parallel evidence rule. So judges do that all the time. And I think, again, judges will see through these things. They'll see what the plaintiff's doing. And if they follow the spirit of this legislation, they would give short shrift to what party was trying to do.
Same point applies to privileged materials, doesn't it?
Yeah, that's right. In
same...
fact, it's no different from without prejudice. You know, letters that were written in without prejudice. It's the same. It's exactly the same scenario, except it applies right from the day that the event, the matter arises, as opposed to waiting to be in a setting with a lawyer where you can create that privilege. It essentially extends the privilege right through. So it's nothing, those sorts of things aren't new for the court. I think, I actually talked to the judges yesterday, and one of the perspective questions to the judges is, what if the judge thinks that there's facts that they may have access to if this exclusion wasn't to apply? The judges are always looking for the best evidence, and this actually prevents them from having before them all the evidence that they might want. I think that raises an interesting question. If it's factual evidence, whether it's the judge who can initiate, in a sense, the inquiry and exercise discretion under Section 8(2), then it becomes a question, well, how does the judge know that there's good facts? And that'll be for the plaintiff or the plaintiff's lawyer to perhaps give rise in cross-examination to something like that. Yes, there's lots of interesting questions for lawyers to tease out. Yes.
This whole thing reminds me of a case that was on ABC Four Corners over 10 years ago concerning a police sergeant in Wagga Wagga, New South Wales, and he was trying to deal with repeat offenders in that particular area. And so with repeat offenders, what he would arrange with consent of the parties, the injurer and injurees, then you get them all together in the room, and they'd sit around in a circle of chairs, and they just talk through the whole incident. And so that the person who caused the injury or the problem issues of the harm, could then listen to the other side, talk about their whole feelings and how it affected their lives. In a very harmful, adverse way. And then you have sort of the person who caused the problem could then start to feel what the effect was, and to the point that it became understood that the repeat offender then made the conscious decision there wasn't a repeat offender again. And so when he put this methodology up to the New South Wales police hierarchy, they were not interested, they didn't care. And so he just felt completely distraught that this should become a regular program to actually work with repeat offenders, get them to understand the harm they're causing. And so he left New South Wales Police Force. He got picked up by the North Thames County in England. He went there, and he applied the same methodology and became incredibly successful. That the repeat offenders who were offending by 8% dropped down to about 8%.
That's very interesting. I haven't seen that particular program. It's very interesting to hear you recount that incident. Certainly in Australia generally, and in many other jurisdictions, common law jurisdictions I'm aware of, these restorative justice programs do operate, where the circle of people where they're usually premised on the offender admitting that the offence, first of all, and then they have an opportunity to participate in a restorative justice process. where they have an opportunity to benefit from participating in the process, usually in mitigation of their sentence, but also to try and reconcile the parties. It's restorative. It's restorative justice. And it is used in a lot of contexts. It's used in a lot of contexts in Australia. I'm not sure whether the fact that he was working particularly with repeat offenders in some way disqualified those people, but certainly with juveniles, it's used very commonly in many countries with juvenile offenders, because then they're seen as being at an age and stage in their life when they could mend their ways more readily. Whereas a repeat offender, someone who's robbed a bank 3 times, might be seen as not worthy of having public money put into a process of that nature. I don't know the reasoning behind the New South Wales Police Department government's attitude. But certainly, as you say, there are many, there can be restorative and therapeutic benefits. Of course, like all of these sorts of criminal justice initiatives, there'll be proponents and detractors. People will say that it's only being used by someone to get a reduced sentence, and how do we know if they're sincere when they say, I'm terribly sorry, I won't do it again? Goes back to that question of sincerity. How do we judge it?
I have asked a question in relation to the term of statement of facts, because wouldn't it be difficult to distinguish it from an opinion? For example, if the bus driver said, I may have crossed a red light, but I'm not sure. Would it be protected or not?
Yeah. Well, there we go. You can start going down that rabbit hole of what is a statement of fact and when is a statement of opinion a statement of fact. We know that from misrepresentation. It's a body of law that is quite well developed, where the courts can say that a statement of opinion can be a representation of fact, and so on. I think that what we have to keep in our minds all the time is that there are plenty of examples of courts in the common law, and I can point to Australian courts, where even without apology legislation, the courts would say, look, the person said they were sorry and said, I made a mistake, or I was inadvertent, or I was careless. That doesn't prove anything. We are the arbiters of, as a matter of law, of determining whether a person is liable. And therefore, whether it's fact or opinion, in the end may not make no difference, because it may still be evidence that's of little value. Because what the bus driver thinks was the problem is not necessarily what the law would say is the basis for imposing liability. So it's an answer and a non-answer in a sense. I'd say, yes, it could be difficult to distinguish between facts and other things, but often it just won't be necessary, because the inquiry for the court is to determine what happened and was there a breach of a duty of care, usually in a tort case. And what was said by the parties doesn't necessarily determine the answer to that question.
By analogy, it's the same principle as applies in contract, isn't it? What the parties thought they were doing in terms of what they agreed is irrelevant. It's all the court.
That's right. So whether or not a party has repudiated their obligations has nothing to do with what they might think they've been doing. Ultimately, only a court can determine whether a party has repudiated their obligations.
Yeah, just a follow-up of this gentleman's question is that you accept that the factual elements included in the apologies to be examined. But what is meant by include in the apology? Is there any operational ways to define what is included?
I think it's that's always going to be a demarcation issue for a court. I think the best illustration is the Canadian case, which was looked at very carefully. It's been looked at in the consultation process by a number of people in academic writing, including myself. And that is a case called Robinson and Craig, where a lawyer had been acting for a client on a commercial matter, failed to check on something, and realised afterwards that it cost their client money, and so the client sued them for damages. And the lawyer wrote a letter apologising and saying that they'd made a mistake and that they'd done something inadvertently, and set out what had happened, probably thinking it was all going to be covered by the Alberta Evidence Act, which has apology protecting legislation in it, possibly thinking that, or thinking it would be inadmissible. But the judge then, the master, in fact, of the court, had to go through and work out which parts of the letter were admissible and which parts were inadmissible. And so that became an exercise of saying, well, this wasn't, this was, this wasn't, this was. That exercise will still exist under the Hong Kong legislation, except it'll be more expansive of what would be in, and what would, the closeness of the connection of the statement of fact to the apology will be the issue in question. The purpose behind this provision, I think, of Section 4 and Section 8 was to say that if a Robinson and Craig case arose in Hong Kong, where a lawyer set out in a letter what had happened and sorry for it, that essentially everything they said that would be relevant to the question of fault or liability would be inadmissible. So then it would create similar to what being without prejudice would do for the whole letter.
Can I follow that on that as well? Because it's easy to say let's the judge decide, but being a petitionist, it makes a sort of moot point and it's difficult to advise the client. What would you say on that? Make the life of the petitioner, the life of petitioners more difficult to.
For the practitioner, yes. Well, I guess I think people would still benefit from advice about what they're going to say if they want to make an apology. I think being aware of what you're saying and why you're saying and how much information you are willing to share at this point in time would be very important. So there's two scenarios, I guess. There's the client comes to the practitioner where the client's already said everything. Well, what are you going to say then? You say, well,
maybe very difficult to settle the matter. So because on one hand it's like this, on the other hand, you don't want to have a one-hand lawyer most of the times being a client.
Well, could you explain what you mean? It'd be more difficult to settle the matter. Why? Because you think that the plaintiff...
Because you can always say this have two sort of scenarios, two sort of interpretations, leave it to the court, leave it for the judge to decide. But the thing is, I mean, the clients will like to have a more sort of concrete answer.
I see. When I've been saying leave it to the court, I've been saying leave it to the court to work out what the meaning of the ordinance is. That's mostly what I'm referring to. I agree that you don't want to leave it to the court to decide who wins the case.
Yes.
When it comes down, but in terms of fleshing out the meaning of the words used in the statute, only the court can do that.
Yeah, that's true.
So for the practitioner, I think, this is my advice, this is what I believe personally, is that when something's happened, where one person is saying to another, you're at fault, you're the cause of the problem, you did it, all of those sorts of things, I believe that the person who is being accused, the defendant, needs to look carefully at what it is they're willing to say and what they're not willing to say. They might say, for example, I'm willing to say that these things happened, and I'm willing to express certain types of emotional response to what's happened. And I'm certainly maybe willing to recognise how this has affected you and so on. But you're not required to admit liability. If you don't believe you've done anything that would be legally wrong, you're not required to say that. It's not a forced admission of liability. And I think that's the advice that I would always give to a client is, do you want to settle on the basis that you're liable? Well, then go ahead. But if you don't want to admit that you're liable, but you still would like to convey some expressions, then do that too. That's why I started with talking about there being components to an apology. You don't have to have all of them necessarily for a matter to settle. There's plenty of evidence that shows that people will settle matters where all they've had is an expression of regret without an admission of liability. It happens all the time in commercial settlements. And so I don't think anything's changed in that regard. And I think lawyers should go on advising their clients to only say what they really are willing to say.
I think that is the life of practitioner.
That's the life.
Just like the recent Court of Final Appeal decision. Friend, may mean someone you don't know. Well, if you advise, you have just based on your judgment, based on your knowledge of law.
Yes. Well, that might be a nice finishing point.
Thank you very much for your active participation. Maybe we can continue afterwards. There are some copies of books here that we go over, and if you're interested, please look at them before you leave.